So welcome back, dear students. Today we will start with Unit 4, and the first lecture of Unit 4 is Nature of Directive Principles of State Policy. You know, we have studied the details of fundamental rights as given in Part 3rd of our Constitution, and now Directive Principles of State Policy are referred in Part 4th of Constitution of India. This portion, Directive Principles of State Policy, they are the central or most important part of Constitution of India. You can say that Directive Principles of State Policy are the kernel of Indian Constitution. These principles of state policy, dear students, aim to create social and economic conditions under which the citizens can lead a good life. They also aim to establish social and economic democracy through a welfare state. These directive principles of state policy are positive in nature, and these principles increase the power and functions of the state. These principles aim at establishment of a welfare state by securing social and economic justice. These principles are based on socialistic thinking broadly. The directive principles of state policy, thus, they constitute a very comprehensive social, economic, and political program for a modern and welfare state. These principles emphasize that state shall try to promote welfare of people by providing them basic facilities like shelter, food, and clothing, roti, kapda, or makan, welfare state. Our constitution deals with directive principles of state policy, and these principles envision for all citizens the equality of opportunity and adequate means of livelihood, avoiding concentration of wealth in few hands. In short, the directive principles envisage equality, liberty, and freedom for citizens. According to Dr. B.R. Ambedkar, these principles are novel features of the Constitution because these principles act as a guideline for the state, and state should take into consideration while coming up with some new policy or any new law. But the point to be noted here, my dear students, is that no one can compel the state to consider and follow all these principles mentioned in the chapter 4th. Why? Because directive principles of state policy are not enforceable. They are not justiciable. As I told you that part 4th of the Indian Constitution consists of all the directive principles of state policy from Article 36 to 51. Article 36 of part 4th, first of all, defines the term state because it is a duty of the state to promote directive principles of state policy or to implement these principles. So definition of state was essential, and word state has been defined in Article 36 as the one who has to keep in mind all the directive principles of state policy before formulating any policy or law for the country. And the definition of state in part 4th will be the same as that of part 3rd. We have learned the definition of state from Article 12. So the same definition will apply in the part 4th also, unless the context otherwise requires a change in it. In Article 37, the nature of directive principles has been defined that directive principles are non-justiciable. They are not enforceable through courts of law. So 36 is definition of state, 37 is the nature of directive principles. Now 38 to 51 contains all different directive principles of state policy. 36 to 51 under part 4th of Indian Constitution deal with directive principles of state policy. They are borrowed from Constitution of Ireland which had copied it from Spanish Constitution. These directive principles, dear students, are classified under the following categories. That is, few principles relate to economic and socialistic pattern. Few can be classified as political and administrative. Some of them can be classified as justice and legal. Some of them can be classified as environmental protection, protection of monuments, and international peace and security. So if I may summarize these directive principles of state policy, the summary states that Article 36 deals with the definition of state. 37 says that Part 4th of Indian Constitution shall not be enforceable in any court of law. 38 says that social, political, and economic justice is to be provided to all citizens. This social, political, and economic justice is mentioned in our preamble also. 39 says what would be the principles of policy. 39 capital A says that free legal aid is to be provided to all the citizens of the country. And in compliance of 39A, you know that Legal Services Authority Act of 1987 has been enacted by the Parliament, under which the Lok Adalats are being held and free legal aid is given to the needy people. Then Article 40 deals with organization of village panchayats. 41 talks about welfare government. 42 says securing just and humane work and maternity relief. Under this implementation of Article 42, Maternity Benefit Act is there to protect the interest of the ladies. 43 Directive Principle talks about fair wages and decent standard of life. And Minimum Wages Act is the example where this Article 43 for fair wages has been implemented. Then 43 capital A was added later on, which deals with workers' participation in management. Then 43B was also added later on, which speaks about promotion of cooperative societies. 44 talks about uniform civil code. We are yet to achieve uniform civil code in our country. And dear students, as you know, that Goa is the only state which has a uniform civil code. Nowhere else in the country, uniform civil code is applicable. Then Directive Principle of 45 talks about infant and child care. 46 talks about protection of scheduled castes and scheduled tribes and other weaker sections from exploitation. You know, SC/ST Prevention of Atrocities on SC Act has been passed for protection of scheduled castes. The directive contained in 47 talks about nutrition, standard of living, and public health. The directive given in Article 48 talks about scientific agriculture and animal husbandry. 48 capital A speaks about environment protection and wildlife protection. Then 49 Directive Principle in Article 49 deals with protection of monuments and places and objects which have national importance. Article 50 talks about judiciary should be separated from executive. You know, in an old CRPC, the judicial magistrate used to work under the control of district magistrate. That is an executive officer. But in new CRPC of 1973, the control of judicial magistrate has been taken away from district magistrate. And now all the magistrates are under the superintendence and control of the respective high court, district judge, and chief judicial magistrate. So in theory, the judiciary has been separated from executive so far as criminal procedure is concerned. Then the last directive principle of state policy is that state shall promote international peace and security. This is also essential. If our central government has sent certain vaccines of COVID-19 to America and other countries, so it is essential to keep friendship between the states so as to promote international peace and security. So this is the last directive principle contained in Article 51. Dear students, these directive principles of state policy can be divided into following heads according to various thinkers. Few thinkers are socialist thinkers. So according to socialist thinkers, the directive principles contained in 38, 39, 39A, 41, 42, 45, 43A, 47 are covered according to socialist principles. And if we talk about Gandhian principles, then organization of village panchayats, fair wages and decent standard of life, workers' participation in management, promotion of cooperative societies, protection of scheduled caste and scheduled tribes and other weaker sections of the society from exploitation, nutrition, standard of living, public health, scientific, agriculture and animal husbandry are all topics covered under Gandhian principle. Then few directive principles can be classified as intellectual principles, like uniform civil code, infant and child care, scientific and agriculture, animal husbandry, environment protection, wildlife protection, protection on monuments, separation of judiciary from executive, and state shall promote international peace and security. These items are covered under liberal intellectual principles. So dear students, the most important point regarding directive principles of state policy is that they are non-justiciable rights, which means that they cannot be enforced through a court of law. These principles lay down the objectives and framework according to which policies and laws should be made. If a directive is infringed, no remedy is available to the aggrieved party by way of judicial proceedings. I have highlighted these words, no remedy is available. If a directive principle of state policy is not followed by the state, then no remedy is available to the aggrieved party. He cannot go to the court for enforcement of these principles. So these principles refer to principles or orders in the Indian Constitution that direct the policy of a state and indicate what the state policy should be. These elements always guide the government, and these principles are mentioned in the Constitution because these elements clarify the ideals of a state. And the sanction, what is the sanction behind directive principles? The sanctions behind the directive principles are political sanctions, and they are based on sound constitutional and moral obligations. Article 37 of the Constitution lays down that it shall be the duty of the state to apply these directives in making laws. So whenever Parliament will make any law, they will keep directive principles in mind. The next question, my dear students, is whether directive principles can be amended. Yes, of course. For amending directive principles of state policies, the constitutional amendment is required because these principles are part of Part 4th of Indian Constitution. And it bill has to be passed by special majority of both the houses of the Parliament. Post-independence, there have been number of amendments to the Constitution, and some of them are pertaining to directive principles of state policy. So far as the amendment in directive principles of state policy is concerned, the changes, if you want to bring, they require a constitutional amendment, which has to be passed by special majority of both the houses of Parliament, which means that an amendment requires approval of 2/3 of the members present and voting, and by absolute majority of the house, whether it may be Lok Sabha or Rajya Sabha. So from both the houses, bill has to be passed by 2/3 majority, 2/3 members of present and voting, and by absolute majority of each house. So directive principles can be amended by a special majority. Here is an example before you. Article 31C. This article was amended by 42nd Constitutional Amendment Act of 1976, seeking to upgrade the directive principles of state policy. Government wanted to upgrade the directive principles as compared to fundamental rights. If laws are made to give effect to any of the directive principles overriding the fundamental rights, they shall be invalid on the ground that they take away the fundamental rights. In Minerva Mill versus Union of India, the Supreme Court ruled that 42nd Constitutional Amendment to the Article 31C is not valid and ultra virus. Meaning thereby, the Parliament wanted to implement the directive principles, and they said that if laws are made to give effect to any of the directive principles overriding the fundamental rights, government says they shall not be valid on the ground that they take away fundamental rights. But Supreme Court says no. This portion of Article 31C is invalid. I have detailed out this portion, which was declared invalid. There are two cases on this point itself. You see the Article 31C portion shown in blue color in the first brackets was declared unconstitutional in Minerva Mills case. The language of Article 31C is, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing. Now see, from here the blue bracket starts. Towards securing all or any of the provisions laid down in Part 4th shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the fundamental rights conferred by Article 14 or 19. This portion kept in bracket shown in blue color was declared unconstitutional in Minerva Mills case. And second portion, see, there is another portion shown in the bracket in blue color, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. This portion was declared unconstitutional in Keshwanand Bharti's case. See, the government wanted to promote directive principles and suppress the fundamental rights, but the court says no. Court has reversed this equation. I have written in the bracket, Part 4th is equal to Part 3rd. Government says that fundamental right should be given preference to fundamental rights. The government's equation is 4 upon 3. But the court says no, it should be 4 is equal to Part 3rd. Meaning thereby that by these two cases, Minerva Mill case and Keshwanand Bharti's case, Part 4th of Constitution dealing with directive principles of state policy was equated with Part 3rd containing fundamental rights. Then Article 38 Clause 2 was added by 44th Constitutional Amendment Act of the Constitution by way of amendment in the chapter of directive principles. And then 39 capital A was added, which directs the state to secure equal justice and free legal aid. This was added by 42nd Constitutional Amendment Act 1976, and 38 Clause 2 was added by 44th Constitutional Amendment Act. Then 43 capital B was added, which directs the state to strive for promotion of cooperative societies. This article was added by 97th Constitutional Amendment. Then Article 45 is there, which speaks about provision for free and compulsory education for children, was added by 86th Constitutional Amendment Act of 2002, and 48A was added by 42nd Constitutional Amendment Act, which ensures protection and improvement of environment and safeguarding of forests and wildlife. Then Article 49 was modified by 7th Constitutional Amendment Act of 1956. Now, dear students, let us summarize the characteristic features of directive principles of state policy. Number 1, directive principles are not enforceable in a court of law. Number 2, they were made non-justifiable, considering that state may not have enough resources to implement all of them, or it may even come up with some better and progressive laws. Number 3, it consists of all the ideals which the state should follow and keep in mind while formulating policies and enacting laws for the country. Number 4 feature is that these principles are like a collection of instructions and directions which were issued under Government of India Act 1935 to the governors of colonies of India. Number 5 feature is that these principles constitute a very comprehensive economic, social, and political guidelines or principles and tips for a modern democratic state that aim towards inculcating the ideals of justice, liberty, equality, and fraternity as given in the preamble. The preamble consists of all the objectives that needs to be achieved through the Constitution. 6th feature is adding directive principles of state policy was all about creating a welfare state which works for the individuals of the country, which was absent during colonial era. Now, dear students, you must have by now understood the distinction between fundamental rights and directive principles of state policy. You see, fundamental rights are justiciable as they can be enforced, whereas directive principles are non-justiciable, that is, they are not enforceable in a court of law. While fundamental rights establish political democracy, directive principles set social and economic democracy. Then, dear students, if you see the directive principle of state policy contained in Article 36, it says that state shall promote with special care the educational and economic interests of the weaker sections of the society, and in particular, scheduled caste and scheduled tribes, and shall protect them from social injustices and all forms of exploitation. We have also studied that 42nd Constitutional Amendment Act added new directive principles of Article 39 capital A, Article 43 capital A, Article 43 capital B also, and Article 48 capital A. The 44th Amendment Act of 1978 added one more directive principle which requires the state to minimize inequalities in income, status, facilities, and opportunities. How will you minimize the inequalities in income? That you are levying income tax on those people who are very rich, exempting the poor classes for payment of income tax, so that there may be equalities in income of both the sections of the society. Dear students, 86th Constitutional Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21 capital A. And we have seen that Article 37 of the Constitution has declared that all the directive principles of state policy shall not be enforceable in any court of law. But the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Now let us see some critical appraisal regarding the nature of directive principles of state policy, because today we are studying the nature of directive principles. The first criticism is that some of its critics hold that these principles do not carry any importance, as their violation cannot be challenged in the courts. Second, the principles are a mere declaration of the instructions which are to be observed and secured by the state at their will. But the Constitution neither makes them justiciable, nor it mentions any limit to what extent it can be secured. Third criticism is that directive principles of state policy are neither consistently explicit nor properly classified. These appear to be a collection of instructions which are only based on morals, and a state cannot rely merely on morals for its working. Fourth criticism is that several directives lack clarity and they have been repeated at different places. Fifth criticism is that directive to push international peace and friendly relations among all the nations is just a declaration, but the real issue is the securing part of it, for which nothing has been given. Sixth criticism is that part fourth includes some directives which are not complete in actual observation. The ideal is to introduce prohibition, that is, banning the consumption of liquor. But this ideal cannot be really and effectively realized. The states which introduced prohibition had to scrap it later on also. So this directive principle remained of little use. Seventh criticism is that most of the principles are based on old and foreign philosophy, which have lost its relevance now. Eighth, many critics hold that preamble should also enlist all these goals which are given under directive principles, and their description in part fourth has made things more complicated and complex than it was before. Ninth criticism is that directive principles just create an impression about the usage of legitimate power by the state, and the motive is to gain support through promise making and not through inaction. It's mere a promise, whereas no action is taken by the state and no enforceability is there. So, dear students, in nutshell, we can say that these are the principal features of directive principle of state policy, and at the same time, the criticism of directive principles also I have shown to you. So this is all about today's lecture. Thank you very much, dear students. God bless you.